You can give your house to your kids thinking you're protecting it and still end up with a Medicaid penalty. But here's the part most families don't expect. Keeping the house doesn't necessarily make the problem go away either. That's the trap Linda and Daniel were about to walk into. After Daniel suffered a stroke, they were suddenly looking at a nursing home bill of about $9,500 a month. And the house they had spent 30 years paying off was now right in the middle of everything. Linda and Daniel had raised 3 children in that house. They watched the tree in the yard grow taller as the kids grew up, and even after Daniel retired, he still liked sitting outside on Saturday mornings with a cup of coffee. By the time he was 68, the mortgage was finally paid off. The house was worth about $450,000. To them, it wasn't just real estate. It was part of their retirement security, and it was the one big thing they hoped to leave to their children someday. Then, one Tuesday morning, Daniel collapsed on the kitchen floor. He'd had a stroke. The hospital saved his life, but afterward, Daniel couldn't walk safely on his own anymore. He couldn't use the bathroom without help, and the doctor told Linda he would need care around the clock. Linda nodded and held it together in the hospital room. She cried later, sitting alone in the car in the parking lot. Then the family started calling nursing homes, and the number they kept hearing was about $9,500 a month. That's $114,000 a year. And nobody could tell Linda whether that bill would last 6 months, 2 years, or much longer, so she pulled out Daniel's Medicare card. Her first thought was probably the same one a lot of families would have. At least we have Medicare. And for a while, Medicare did help. After Daniel's hospital stay, he qualified for skilled rehabilitation. For the first 20 days, Medicare covered his eligible skilled nursing care in full. Starting on day 21, the family was responsible for about $217 a day in coinsurance. And even if Daniel kept qualifying for skilled care, Medicare coverage in that benefit period couldn't go past 100 days. If he stopped needing skilled care before then, the coverage could end sooner. Daniel stayed long enough to reach that limit. That's when Linda learned the difference she had never really understood before. Medicare could help with short-term skilled nursing care. It wasn't going to keep paying indefinitely for the everyday help Daniel still needed. The nursing home bill didn't disappear. $9,500 was still coming due every month, with no clear end in sight. So Linda started doing the math. At that pace, their savings weren't going to last forever. Then she looked at the house. If they sold it, she thought, that money could eventually disappear into nursing home bills too. And that's when another idea started to sound reasonable. If the house belongs to our son, then it isn't ours anymore. Maybe Medicaid can't touch it. Maybe at least the kids will still have something left when all of this is over. So Linda and Daniel signed the house over to their son. They didn't talk to an elder law attorney first. A few weeks later, Linda was sitting in a plastic chair at the Medicaid office waiting for her turn. The worker went through the paperwork and then asked, almost casually, for records of any assets they had transferred during the previous several years. Linda handed over what she had. She still didn't understand why the question mattered. Linda and Daniel had been thinking about the future. Medicaid was about to look backward. That's where Medicaid's lookback rule comes in. The general federal rule is a 5-year lookback, although some states use a different period. Medicaid reviews certain transfers made before you apply for long-term care coverage, especially assets that were given away or transferred for less than fair market value. And there it was, a $450,000 house handed over to their son for nothing. Now, Medicaid doesn't calculate the penalty using the $9,500 Linda happened to be paying every month. The state uses its own formula based on nursing home costs to calculate the penalty. So exactly how long that penalty lasts depends on where you live. But with a transfer that large, you're talking about something that can be measured in years, not weeks. When Linda heard that, she went quiet. She had given the house to her son because she thought she was protecting the family. She had applied for Medicaid because she thought she was doing the responsible thing. Now those two decisions were working against each other. By then, the house was already in their son's name, and Linda thought at least that part of the problem was behind them. It wasn't. During the penalty period, Medicaid may refuse to pay for Daniel's long-term nursing home care. And the bill doesn't stop just because the name on the house changed. $9,500. every month. The family thought they had protected the house. Instead, they could be left paying the nursing home bill at exactly the moment they needed help the most, which brings up the obvious question. Why give the house away at all? Why not just keep it? And in some situations, keeping it may have been the better choice. A primary residence can often get special treatment under Medicaid's asset rules, especially when the applicant or a spouse is still living there. So if Linda had kept the home, Daniel could likely have still qualified for Medicaid while she was alive and living in it. But keeping the house wouldn't necessarily make the problem disappear, because a home that looks protected while you're alive can become a different issue after death. For people age 55 and older, states generally have to try to recover certain Medicaid costs after death. That can include nursing home care and some other long-term care services. That's Medicaid estate recovery. Imagine Daniel spent several years in a nursing home, with Medicaid paying the bill. That total could easily climb into the hundreds of thousands of dollars. After Daniel died, the state could seek repayment from assets in his estate. Depending on the state and how the property is owned, that may include the home. Now, this usually isn't a story where government agents suddenly show up at the front door and take the house. That's not how it normally works. What can happen is that the state files a claim against the estate, and that claim can reduce what eventually passes to the children. There are important protections. If a surviving spouse is still alive, federal law limits when estate recovery can happen. There are also protections involving a child under 21 or a child who is blind or disabled, and every state has to provide a process for requesting an undue hardship waiver. Beyond that, the details can vary quite a bit from one state to another. But for Linda, the basic problem was now clear. Giving the house away could create one problem. Keeping it could leave the family facing a different one later. And that's really what this story is about. Linda's biggest mistake wasn't that she had never heard of every Medicaid planning strategy. It was timing. By the time she started asking these questions, Daniel was already sick. The nursing home bill had already arrived, and the family was trying to protect their assets in the middle of a crisis. That's when your choices start getting smaller. If Linda and Daniel had looked at this while they were still healthy, maybe in their early or mid-60s, they might have had more options. One option families sometimes consider is a Medicaid Asset Protection Trust. It's generally an irrevocable trust, which means you don't simply put the house into a trust and keep complete control as if nothing changed. It has to be set up correctly under the rules in your state, and the assets usually have to be transferred early enough to get beyond the lookback period that applies. There's a trade-off too. With an irrevocable trust, you're giving up a meaningful amount of control over the asset. But if Linda and Daniel had planned early enough, and the house had been transferred properly, the result might have been very different. In some states, families also look at something called a ladybird deed. It can let a homeowner keep significant control of the property while they're alive, while directing the home to pass to someone else after death. But it isn't available everywhere. And even where it is available, whether it helps with Medicaid planning depends on the state's rules and the family's situation. For Linda and Daniel, it would have been something to look into before they made a rushed transfer to their son. There's another exception worth knowing about. Suppose their adult son had actually lived with them and cared for Daniel for at least 2 years before Daniel entered the nursing home. And suppose that care helped keep Daniel out of a nursing home during those 2 years. In some circumstances, transferring the home to that caregiver child may qualify for an exception to the normal transfer penalty. The details matter, but the larger point is simple. The same house transfer can have a very different result when it falls under a valid exception instead of being made in the middle of a crisis. And Linda may have had another protection she didn't know about. When one spouse enters a nursing home and the other spouse stays at home, Medicaid has special rules designed to keep the spouse at home from becoming impoverished. Medicaid even has a name for that spouse, the community spouse. Those rules can allow the spouse at home to keep part of the couple's countable assets. Exactly how much depends on the couple's finances and the rules where they live. And unlike a trust, this isn't necessarily something you had to set up years earlier. It's built into the Medicaid eligibility rules. If Linda had understood those protections before signing over the house, she might have looked at other legal options first. And this isn't some strange situation. that only happens to a handful of families. Federal research suggests that about 7 out of 10 people who reach age 65 will need significant long-term care at some point later in life. Linda and Daniel weren't trying to cheat anyone. They weren't hiding money because they had bad intentions. They simply reached the crisis before they understood the rules. And once the crisis arrived, every decision became harder. Transfer the house too late, and the look-back rules can work against you. Keep the house, and estate recovery may still become an issue later. A health crisis today doesn't erase financial decisions you made years ago. That's why protecting a family home doesn't begin when the nursing home bill arrives. It begins while you're still healthy enough to plan. The yard may still be there. The tree may still be there. The house may look exactly the same from the street. But once a long-term care crisis begins, what happens to that house can become much more complicated than most families ever expected. So before your family needs these answers, there are 3 questions worth asking. Do we already have a plan for long-term care and the house? Do we understand what protections are available if one spouse has to enter a nursing home? And if this happened tomorrow, do we even know which elder law attorney we would call? If the answer to all 3 is no, start there. Medicare, Medicaid, Social Security, taxes. Those rules can decide a lot about what you actually get to keep in retirement. Subscribe, and we'll keep working through those rules together.